Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, welcome everyone to this episode of Fairly Competing. We've got a great show planned for you today. We're going to be talking about ways in which the DTSA could perhaps be improved. And so, John, you wrote a blog article about this issue, and I guess I'll note you humbly suggested some amendments to the DTSA, including the possibility of a safe harbor rule for folks who maybe take information unintentionally and want to sort of comply and return the information. And then also to perhaps add to the DTSA an early trade secret identification. So you want to maybe talk about those two issues, and we can give our perspectives as well.
Yeah, that'd be great. Russell, as you recall, I think the impetus for this came at a committee meeting we had with the AIPLA's Trade Secret Law Committee, and Jim Pooley had talked about perhaps some ideas or thoughts that keep us busy in terms of improvements of the DTSA. I don't think we addressed either of these, but I gave it some thought and attempted to address two problems that I see in my practice, and I suspect both of you have seen it from time to time. As you indicated, Ben, the first proposal is what I described as a safe harbor rule. And the reason for this is increasingly I've been doing probably about 50-50 defendant versus plaintiff work. Early in my practice, I was heavily employer-oriented, did a lot on the plaintiff side. But as I've represented more and more employees, I've become sympathetic to the plight that they sometimes face with the employer that won't go away. And the fact pattern of this type of dispute's been fairly common, and it really follows the following script. An employee does something they shouldn't do, either out of zeal to hit the ground running at their new employer or inadvertently, but they exercise poor judgment and they take things that they shouldn't take. Before they can really evaluate what they've done or consult with counsel about it, they get sued. And they quickly realize the error of their ways. They realize the predicament they've created for themselves, and they find themselves looking down the barrel of a very expensive litigation, and they want to do the right thing at that point in time. It's a situation that's arisen probably a half dozen times for me. Maybe that's a little high, but it seems like it over the course of the last 3 or 4 years. The problem is the employer, having enlisted the help of counsel, is generally reluctant to back off. And despite the best efforts of the employee to try and make it right, to provide the employer with whatever evidence or access that they need to demonstrate that there's been no further dissemination of the confidential information or trade secrets, and despite the willingness to enter into an agreed order not to use the key information, the employer is unwilling to relent, and what becomes a dispute over trade secrets becomes instead a dispute over recovering attorney's fees at the end of the day, sort of trying to squeeze blood from the proverbial turnip. So having encountered that situation and faced down the barrel of a dispute with an employee that really can't afford the litigation, I was sympathetic and thought to myself, what's the best mechanism to try and extract someone from that situation? And it occurred to me there was a good parallel to some extent with Rule 68 under the Federal Rules of Civil Procedure. And for those of you that have not invoked the rule, it basically provides insulation to a defendant potentially for attorney's fees should they make a good faith offer that is in line with what a jury or fact finder ultimately awards. Rule 68 by its express terms deals mostly with costs and the ability to recover those costs, but there are rulings out there where courts have used it to provide insulation to a defendant from an attorney's fees claim later on. So I thought that would be a good parallel. So under my safe harbor provision that has been noted, I've humbly proposed, the employee would do the following to get the benefit of the protection. He or she would agree to a reasonable injunction, and they would agree to reasonable disclosure and discovery, perhaps forensic review as well, of their devices to satisfy the employer that they have capped the problem and that they don't face any further risk. Once they've done that, they would then have the benefit of the rule and be able to protect themselves in a situation where an employer decides he or she wants to push the envelope and continue the litigation. So I know, Russell, you and I talked a little bit about this situation. It's one that you'd encountered, and you reminded me of a situation where there's always someone that might be a little bit more unscrupulous than they should be and might take advantage of this safe harbor. And then we might later learn that they misled the employer or misled their lawyer or done things that they shouldn't have done and shouldn't get the benefit of the rule. So there are permutations like that we need to work out. But I thought that this was a common problem and a solution that might help with that problem. So that's proposal number one. And before I turn to proposal number two, I'd be interested in getting any feedback or thoughts either of you have and whether you've encountered this situation as well.
Ben, you want to go, or I'm happy to take a turn, whichever.
Yeah. Go ahead, Russell, and then I do have thoughts, so I'll jump in.
Okay. Yeah. I mean, I think this is a very common issue that comes up in these kinds of cases, unfortunately, all too often. In my experience, most employees, when they are sued, their first reaction is panic. And oftentimes you'll see things deleted that shouldn't be deleted. But that is hopefully before they've gotten advice of hopefully they don't do it in the first place. But if they do, it's hopefully before they've gotten advice of counsel. And then they typically are more than willing to agree to turn everything over and be done with it. And if they haven't used the information, and there's really no harm at that point, what's the harm at that point? The harm is that the information left a secure, not secure enough, but a secure facility and was returned. And so as long as it's deleted and you go through your forensic protocol, you do all the deletions, that should be fine. The problem, John, that you and I were talking about and that you referenced is a real problem. The idea that an employee could have, when they had their thumb drive in, let's take the example. Let's just walk through a hypothetical, right? They stick a thumb drive into a computer at work. They download a bunch of information onto the thumb drive. They take that home. They stick it in their computer. They download a bunch of information onto their computer. All of that is traceable. What isn't traceable, or may not be, depending upon operating systems and all the rest, and to some extent, employee honesty, is if they took that thumb drive and put it into another computer that's never identified to anybody. Because usually, again, depending upon the operating system, looking at the thumb drive won't tell you what devices the thumb drive was stuck into. It will only tell you what information is on the thumb drive. And so you need to look at the devices it was stuck into in order to know what information may have been moved off. So you do have that problem. And that is a real problem. And I understand from the employer's perspective. But if you're not going to be able to get that through a cooperative process in the beginning, or even with a court order in the beginning, it's not like you're going to come by it later. It's not like suddenly halfway through the case, the employee is going to say, oh, by the way, yeah, I guess I should tell you there was this other computer that I stuck it into, right? If they didn't tell you that at the beginning, closer in time to when it happened, they're far less likely to tell you later. But you never know. And maybe something will show up later. But I think, to your point, that kind of circumstance where the employee doesn't disclose the second computer is a potential problem. I don't think it's a common problem. And so I do think that, as you mentioned, we can address that in other ways. We can address that through steps that have to be taken at some point later and consequences that will arise at some point later if it comes out that the employee actually was not forthright up front. And you can check them at multiple points. You can check at the time you reach any sort of resolution with them. You can have a forensic review. You can get an affidavit. You could even do a deposition if you want, right? To try to just make sure you've got everything locked down. but quickly and inexpensively. It doesn't need to be a full day deposition starting with, when they were born and what they've done in the 30 years before they stole the information. And then once that's all locked down, you're done, unless you want to check in at some point later, and you can have some sort of check-in process. But I do think the sort of Damocles, recognizing for the employee, look, this is your way out. This is your way out with very little liability at this point and very little cost in terms of attorney's fees, both ours and the other side. So you may have to pay in the context of a misappropriation claim. And then if you're not forthcoming here, you will wind up in a much worse position than if you hadn't agreed and you just move forward with the litigation. So anyway, I think there are ways to do it. I think, John, when you came up with that idea, when you mentioned it to me, I thought it was a really, really fantastic idea for a very common and really difficult issue that comes up in these cases most of the time, because the reality is most of these cases involve an employee. Most of the cases involve, it's an employer, which typically will have deeper pockets than the employee. And the employee has to defend against something. And there is literally no upside to the employee. And if they haven't moved the information, they haven't used it, moved it to a new employer or used it, it seems like there's an easy way out here. And that saves everybody time and resources and frees up the courts for other things that the courts really are needed for.
Yeah, John, Russell, I agree. I mean, this does come up frequently. I'm defending a couple right now of this very situation on behalf of the new employer, but a couple of employees, a few employees that did, forwarded themselves information or kept information in other ways. The thing I struggle with is how could you really word the safe harbor in the statute itself in a way that would be practical to implement. So, for example, what do you do in the situation where someone takes information, let's say it involves some customer information, does that injunction just prohibit the use or disclosure of the information? Or does that injunction, as we all know, sometimes you go further if you're representing the party whose information was taken, you may be insisting on an injunction that prohibits any solicitation or doing business with those customers for some period of time, because you can't be 100% certain that the injunction against use or disclosure is going to be sufficient. And so I think that there's so many variables in these cases, and we've all settled, countless numbers of them with all different permutations of what that final injunction looks like, that I'd be concerned that there might be, it might be very hard to create legislation that would address that. Now, the thing that I thought about is, that might be something, for example, for Sedona to get involved with and publish recommendations or publish, what do we call those in Sedona? Commentary on, sort of the reasonable and appropriate measures and the types of injunctions that can and should be entered in those cases. But John, I think the thing that I really like that you've seized on is the shifting of the burden with respect to attorney's fees. I find, Rule 68 is just so limiting because it really does just apply to costs unless you have a statute that says, as the prevailing party, you get your attorney's fees. And, I don't think, at least you guys can correct me if I'm wrong, I don't think the trade secret statutes have the kind of prevailing party attorney's fees that would be necessary in an offer of judgment situation under Rule 68, right? Like Title VII, you make an offer of judgment that's not inclusive of attorney's fees. The judge very well could award attorney's fees once the judgment gets entered. Where I think with the trade secret statutes, there's more proof that's required in order to get your fees. You don't just automatically get fees by prevailing. And so I do think something along those lines, where a fee shifting provision, or at least a provision that would cut off the recovery of any attorney's fees by the plaintiff if they get no more than what the defendant offered early on in the way of an injunction, I think that has intrigue for me. We have a statute here in Georgia that is our version of Rule 68. The difference is that it's an offer of compromise. So first, you don't actually have to offer a judgment. You can just offer a settlement. on a monetary claim, if the plaintiff doesn't get at least 75% of what you offered, then you can recover your attorney's fees as a defendant. It was part of the tort reform efforts here many years ago. And, it's got its limitations because it only applies in tort claims. So if you have a mixed case of tort and contract, it gets complicated. But something like that would, sort of shift the burden to the plaintiff. If the plaintiff is really going to continue on after it gets what it really needs, which is, the assurance that its information has been quarantined and then deleted, and wants to continue on, then I do think they're having some consequence for that plaintiff that doesn't get anything more would be appealing. Of course, we've all been in the cases, I'm in a couple of them right now, where the former employer, they're upset about the information being taken, right? But they're also, they're doing it to send a message like, don't leave and go to another, a competitor, because if you do, we're going to sue you. And so there are always those other motivations going on in these cases that, may make it difficult to convince sometimes a plaintiff to, get their information back and then shut the case down.
Yeah, but John's idea would actually help with that too,
Sure.
because it would shift the liability, the risk for liability over to the former employer. If you made it closer to what you have in Georgia as a statute, right? So in other words, the offer of judgment from the employee, or call it an offer of compromise, whatever. I actually don't care whether it's a judgment or a compromise. I just think that process that John identified is it's the right stage of the proceedings to be able to cut off the continuation of the proceedings. But then you can also supplement that with, if the plaintiff does move forward after that, and nothing else comes of it, any legal fees incurred by the defendant will have to be paid by the employer, because that kind of correlates with the DTSA's attorney's fees provision that says, misappropriation claim brought in bad faith will also result in attorney's fees, this time for the defendant. So those two things kind of go well together. And so I could see a benefit to that. The problem is, one of those practical issues that you come across is that the attorney's fees issue only gets resolved at the end of the case.
Right.
And
right.
So if I'm an employer and I really am pissed, and, take your scenario that you've identified, because that does happen. The employer says, all right, and they just keep pounding and pounding and pounding, even though the employee took advantage of this Rule 68-like approach. And even though the employer may be on the hook for attorney's fees at the end of the case, but they continue to do it. And so at some point, the employer says, I've had enough. All right, I'm ready to settle. You're the employee. Do you spend more legal fees to defend, hopefully win, and convince a jury that even though you took the information in the beginning, it was okay because you gave it back and they shouldn't get their legal fees? Maybe. But I think that could be a real issue as a practical matter for implementing something like that. But all that tells me is that whatever happens with the DTSA, if it is amended, that it just needs to take these things into account and address them, right? John has identified a really important issue and a solution. And so, to your point, Ben, the solution needs refinement. So we work on that refinement. And I think that through the AIPLA, we could propose something to Congress, because I do think that this is such a good and important and necessary thing that it's worth doing something like that. And Ben, you're the chair. Come on.
Yeah, well, and I think that, like I said, with our statute here, you have that formula of 75%, which you can apply in a damages case, right? Here it is more difficult, but I think that if you had something like a standard that says that once the employee proposes, or the misappropriator proposes the relief.
Alleged misappropriator.
That's right. Proposes the relief, and the defendant does not accept it as an end to the case, then if the plaintiff does not get something like materially more in terms of an injunction, or does not prove any damages, then, and maybe you have to add a damages component to it too, right? Even if the person did nothing with the information, arguably as the forensic costs and some of that part of the damages, as long as the defendant is offering to pay that and has agreed to an injunction that sufficiently should satisfy the plaintiff, you could give the judge's discretion on, when to award fees, but you have these basic parameters.
I like the idea that both of you have suggested about upping the ante for the employer or the plaintiff that is persisting, even though there wouldn't be any further risk based on at least the hypothetical that we've presented. Russell, you mentioned the fact that under the DTSA and the UTSA as well, there's language that imposes liability on a trade secret owner that brings an action in bad faith. And what you're doing is providing some architecture potentially to the maintenance, at least, may not have been initially a bad faith filing, but maintaining the action and persisting it despite having been essentially provided with your remedy.
Yeah, that's a great idea.
That could be a way to do it. I know that when I've dealt with bad faith cases, they're messy because a lot of district courts have this objective element and the subjective element. And it doesn't provide the kind of clear guidelines that one would need. And I think clear guidelines are really what people need to dissuade them from doing this. If they think that they can fight in every nook and cranny and on every hill and on every airfield, to paraphrase Winston Churchill, there's some people that are simply going to do it. But if you can box them in and make clear that they've got exposure, hopefully that'll dissuade someone from doing it.
Yeah, and John, I think there's really two pieces to it, right? There's cutting off the plaintiff's right to recover fees after a certain point, even under a prevailing party attorney's fees provision, for example, in an employment agreement or a confidentiality agreement.
Right.
And then it's the part about then also the plaintiff being at risk of having to pay the defendant's attorney's fees. But I think both of those, because again, I don't want to relate to ongoing cases, but a challenge often is that if you have you're defending where the plaintiff has a prevailing party attorney's fees provision, and you're basically admitting that yes, the contract perhaps has been breached and information has been taken or kept, but you're offering everything that the plaintiff really should need or want. They shouldn't be able to recover any attorney's fees beyond that point.
Agreed.
Yeah. So I think we're all in agreement on this.
Yeah.
All right. Well,
which is one of the few times I think that we have fully agreed on a particular issue.
It is rare.
As chair of the AI PLA Trade Secrets Committee, I'll try to move that forward. I think
there we go.
We talked about that at the meeting in October, right? And then the plan was to start having some legislative subcommittee meetings this year when the FTC dropped a bomb on us in January that derailed the best laid plans.
Hey, April 19th. We're good. Yeah, we're past that now. Now we'll see what the FTC. Everything is in the FTC's hands at this point. So
that's a good point. It's just a wait and see. So maybe now's an opportune time to get that going again.
Yeah, totally.
I'll cover the Second Amendment real quick. I think there's emerging consensus on this, and I don't think it's a heavy lift, and that's the requirement of early trade secret identification. We've talked about Sedona and the importance of its commentaries in defining the law, and there was an outstanding commentary that was put together with a proposed rule for trade secret identification. I don't think any of us were on that team that provided the commentary, but I'm pretty confident we all provided input and thoughts on it. And I thought that group did an outstanding job.
Great.
And my research, at least, and what I've seen is that there is a groundswell within federal courts to impose some requirement of trade secret identification early in the case. My understanding is there are some district courts that have embraced the Sedona local rule or some variation of it, but the majority of courts appear to be moving in that direction. I know the Southern District of Ohio and the Northern District of Ohio both issued decisions requiring early trade secret identification, and there's ample authority out there. So I don't think that one should meet great resistance within the trade secret community, within the litigation community. But I think that's another amendment where you can reach consensus across a wide group of industries and lawyers.
Yeah, I tend to agree, John. I think the question I have, and we could probably do an entire episode on this issue, right? And all of
Maybe
the
we should.
nuances of it.
Yeah.
But the one that I always struggle with is, what do you do in the situation where you're representing, again, we'll use the employer-employee situation because that's the most common. You're representing the employer, the employee, made a copy of their entire hard drive from their company laptop. And I've been on both sides of that case where you got 25,000 files, and then you go into court and the judge is saying, well, Mr. Fink, you got to identify for me which of those 25,000 files are trade secrets before I'm going to give you any relief. I always, typically try to argue when I'm in that situation that, hey, judge, I've got a contract. Contract says you can't take information, you got to return it. So I shouldn't even have to prove any of this. But, for example, in California, there's case law out there that says that identification requirement applies in any case, not just trade secret cases, but any case where you have, essentially a claim of misappropriation of information, even if that's just confidential information under a contract as opposed to trade secrets under a trade secret statute. And, I don't know what you all have seen in that regard, but that's always, I find, a situation where the identification can be a real challenge and a real hurdle to getting relief that you need, relatively quickly.
Well, there's also the timing element of it. The identification requirement increases over the course of the case. So
Sure.
When you file your complaint, it's a very low bar. When you seek a preliminary injunction, you've got a little more of a hurdle, but it's still not the same as before you get discovery, right? Which is kind of that big hurdle. And that does create problems. I agree. I mean, I think that when you're talking about a magnitude of information that is as broad as trying to parse through 25,000 documents on a hard drive, that's a problem. And I think that the only way that you're going to handle that is by identifying a series of trade secrets and then reserving on those, and just basically, depending upon the court, they may or may not allow you to take that approach of categorizing. There's financial information on the hard drive. There's, this on the hard drive. A discovery will reveal the full extent of it. And I do think that'll give you good cause to come back later and expand the scope of your identification as well.
And I'd throw out one other practical issue. I mean, I recognize in the data dump types of cases, it's really difficult in that situation to provide that sort of log of all of the trade secrets that have been taken. But generally, depending on the employee, depending on their position, depending on what the risk is, you're going to know perhaps what's most important. And focusing on that will hopefully can leverage that into getting an injunction. You specifically identify, let's say there are 10 R&D secrets that this person was working on that you really don't want them messing around with. You can build on that later. You get your injunction on that. You hold in abeyance your ability to identify other things. And if you get an injunction, maybe that leads to a reasonable discussion with the other side about resolving it. So I think you're right, Ben. It's still a challenge to address all of that out of the gates, but maybe there are ways you can more surgically address it at the outset, and then hopefully things will fall into place later.
Yeah, don't forget there's also the orders to return everything.
Exactly.
So once you've got everything back and it's out of the defendant's hands, then we're really focused on not using anything that they may remember, and also any damages that may have resulted as a consequence of their use or disclosure before they wound up getting sued, before you found out about it.
For both of these issues, we focused on the idea of amending the DTSA. Are you all familiar with how, like, the Uniform Law Committee would, have they ever considered amendments to or changes to the UTSA? Because it would seem that's just another avenue, maybe a lot not easier, but maybe just another approach, because getting Congress to do something, these days takes an act of Congress.
Well, so Congress does seem to be focused on information, at least on the protection of information. Not when it comes to using non-competes to protect information, but when it comes to just treating it in theory as a trade secret and the things that need to happen as a consequence of that. But I think that going to the UTSA, going to the Uniform Law Commission, they've got the UTSA, which was put in place in 79 and then modified in 85. And even those modifications were not extensive. I mean, there were a bunch, but it wasn't like an overhaul. That's been in place now for nearly 40 years. So I think the odds of getting them to make changes to that, given that it's been adopted in every state except New York and maybe North Carolina, maybe Alabama, there's a dispute about those states. But I think that getting them to make a change at this point is probably unlikely, but it's worth a try. I mean, can reach out to them. Neil was involved on this effort on the uniform, the UREA, uniform restrictive. Yeah, it's a terrible name. It was, and so I was involved as well, and I'm actually partially responsible for that until somebody pointed out, hey, did you notice what the acronym was? But it was too late at that point. So, but I think that Neil can reach out. I can reach out. For the audience, Neil Weinrich is a partner of Ben's who does a lot of work in this area and is an absolutely fantastic lawyer.
Yeah, as I often refer to him, the brains of the operation here.
I'll second that.
Well, John, Russell, this has been a great discussion. I think, John, you've been the catalyst to get the discussion going, and I think we ought to continue it. And I will make an effort through the AIPLA to maybe we can, get a committee together, because I think that is one of the great, the strengths of the AIPLA is it actually does have very good connections on Capitol Hill, and the folks there tend to listen when the AIPLA does raise issues around intellectual property. So that probably would be our best approach to perhaps get Congress interested in making some of these changes.
I think that's a great idea. I think it's definitely worth looking into and then doing if it's feasible.
I agree.
All right. Well, until next time, I hope everybody enjoyed this episode, and you'll hear from us shortly.
Thank you very much.
All right. Thanks, guys.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.